I'm Alistair Smith, a solicitor with Woodhouse solicitors in Middlesbrough. I specialise in inquest work, particularly where there's a state body involved, like a mental health institution, prison, police. And I represent the families, not the body. An inquest is where there's been an unexpected death. It's held in a coroner's court. Our local coroner's court is in the Magistrates' Court at Middlesbrough. It's particularly held where there has been a suicide or a death involving a public body, where that body is under a duty, under an enhanced duty to look after the individuals they've got in their care. So if I take, for an example, a mental health institution, if you're an inpatient, they have an enhanced duty to look after you. If you're under their care in the community, they still need to look after you and make sure that you are kept safe. An inquest most likely would be held when there was one of those bodies involved and they were still involved in the care of that individual. The role of a solicitor is to help a family through the actual process. A family, usually when a suicide or unexpected death occurs, freeze. They haven't a clue what to do because 99% of people have never gone to a coroner's court, been involved with a coroner, or know what an inquest is. So we're there as early as possible to help them with the process, say what it involves, help them to get the answers that they want, and they can be very in-depth. Most importantly, the family needs a voice, and that's why we're here, to give them a voice. I think one of the things families think that we can do is get every answer that they want, and we can't do that. Generally, a coroner has got what's called a scope, i.e. what they're going to cover. So we try and get the full investigation, but we can't get every answer usually. Well, an inquest is actually for the family. What we do for the family, and we insist that we do, is we tell the story of the individual who's died, give a sort of pen portrait, it's called, of that individual, what they liked, what they didn't like, what type of personality they were. And we also give to the coroner a list of the questions that the family want answering. Now, a family can give all sorts of important information. They have the background to this individual. They know more than most usually. And so getting the information from them and giving it to the coroner is vitally important. An inquest is there for the family, so they have the right to question witnesses. They have the right to take breaks, i.e. get upset, because it's perhaps their only time that they can. And they need to fully participate with everything that's going on, so that they feel at the end of the day, or however long that they have been involved, they need to insist that they get involved. They should get legal representation anywhere where there's a government body that can detain them. So they should also, if somebody's been receiving treatment in the community, they should go and see a solicitor. If they have any concerns, they should call a solicitor, and a solicitor may be able to help. Almost invariably, a solicitor will have half an hour with you. We do all the time with people. We're not going to charge them. We're just going to say, well, this is the process. Yeah, I can see that you've got concerns. Either we'll say, we can't do anything, or yes, we can help you. After an inquest, you get the full death certificate. You also get a record of inquest, A record of inquest will cover the 4 questions that it needs to cover. Quite often there's what's called a narrative in the record, and it will talk about how the individual has died. There may well be a longer version that the family will get where the coroner goes through the evidence and then covers how they've come to the conclusions that they have come to. A coroner can, if they have concerns about particular care or what's happened to an individual, make a prevention of future deaths report where they write to the body, they write to both the chief coroner and the body in question and say, please correct this because I'm concerned that other people will die as a consequence. I think for a family, what happens after is that they have the opportunity to reflect. They may wish also to bring a civil claim, so that if they wanted to, after hearing all the evidence, they can. Many people don't, and quite often there isn't a claim, but there is that potential as well. If anyone doesn't agree with the outcome, you can apply to that coroner's court for it to be set aside. It only ever happens in the very rarest occasions, and there has to have been something that really has gone dramatically wrong with the process. It can't happen because, for example, you disagree with the conclusion of the inquest. That is almost invariably for the coroner or sometimes a jury. You would take solicitor's advice. It has to be made also within 3 months of that inquest, and you would consider it carefully. The other thing you've got to consider is sometimes for a family, it might be difficult hearing it a second time as well. So it's very difficult for a family, I think.